Welcome to the Far and Beyond podcast, hosted by the Contracts and Fiscal Law Department at the Judge Advocate General's Legal Center and School. This podcast is for the federal government attorneys navigating the complex intersection of acquisition, fiscal law, and policy. I am your host, Major Ellie Sewell.
I'm Major Ed Callahan.
And I'm Major Jason Floyd. Together, we're your co-hosts. And on this episode of Far and Beyond, we'll talk about the Supreme Court of the United States, or SCOTUS. As an amateur court watcher myself, I was blown away to hear the FAR mentioned during an oral argument last week. I literally had to pause my run, Ellie.
I'm not sure what to say about you listening to an oral argument while running.
Say you do it too, right? Doesn't everybody do it?
I prefer just not to run,
No.
but I think it's good that you two want to brag about that. All right. Today's episode is probably a real one. These cases don't directly implicate the issues we talk about on the podcast, stuff like FAR changes or appropriations decisions. Instead, these cases involve contractor liability in state courts and contractor immunity. But it's important to understand these concepts for two reasons. First, the Supreme Court's decisions could drive changes to acquisition law and policy. Second, even if no changes come, these issues could inform how contracting officers make contract awards.
I agree. So let's dive right in. Ed, tell us about Hensley v. Fluor Corporation. What are the essential facts?
I am flashing back to law school with this one. Fortunately, I knew you were going to ask me that question, though. So this case involves former Army Specialist Winston T. Hensley. He was injured in a 2016 bombing at Bagram Airfield, Afghanistan. He sued the contractor, Fluor Corporation, under state tort law for South Carolina. He cited a bunch of negligent-type claims when he did so. Importantly, the Army investigation later found that Fluor's supervision failures were the primary contributing factor, quote-unquote, to the bombing.
Yeah, so that's a tragic bombing, but the question is really a legal question up at SCOTUS, as most are, right? The question hinges on preemption, whether these state tort claims against a defense contractor operating in a combat zone are displaced by federal common law, essentially. Specifically, should the government contractor be granted immunity based on the Boyle Doctrine?
What's the Boyle Doctrine?
Great question. It comes from a 1988 SCOTUS case called Boyle versus United Technologies Corp. The case established the so-called government contractor defense in state law tort cases involving design defects in military equipment. Since then, courts generally bar recovery against government contractors for defects in the design of military equipment if the government is the one who told the contractor how to make the equipment. The contractor conformed to the specifications, and the contractor told the government about potential issues that were unknown to the government. So it's essentially, hey, government, you knew these things were happening because I just followed your orders, and therefore the state law claims have to give way to federal supremacy.
And that makes sense, because the FTCA's discretionary function exception usually prevents suing the government directly over design defect claims when the government controlled those specifications. So the court in Boyle explained that the same defense should be available even when the government contracts for that same service.
Yeah, if it's good enough for the government, it's good enough for its contractors, right? I think that's the takeaway.
Yep.
So the Fourth Circuit took Boyle's rationale, in this case, the Fluor case, and expanded it to cover uniquely federal interests, right? This kind of federal preemption doctrine piece. Whatever underlies the FTCA's combat activities exception could equally apply, just like Boyle did with that other FTCA exception that you talked about, Ed. The court found that preemption applied here because Fluor was so integrated into the combat activities, it was essentially inseparable. The court reasoned that this was necessary to preserve the field of wartime decision-making exclusively for the federal government. Essentially, we don't want a bunch of generals questioned in state law courts in, like, South Carolina about what happened in Bagram.
Yeah, which makes sense.
Okay, but I'm a little confused then, because this sounds like an easy case for the court. What is the petitioner's counter-argument and why Boyle should not apply?
Right, Ellie. So this basically sounds like it's an extension of Boyle. The logic of the argument is, hey, the FTCA prohibits government liability here. Why should contractors be liable? That's a bright line rule. That makes life easy. I certainly like hitting the easy button when I can.
Ed, I also tend to like bright line rules because of their workability. However, I think there are two issues here with a straight extension of Boyle. First, in that case, the court stressed that the government had given the contractor a specific means and method of carrying out the task. It gave it a design specification. Here, the contract language is much less clear. It just requires the contractor to provide base security, essentially. But that doesn't provide the level of detail that a design specification would. After all, we know in service contracts, those contain performance specifications, which don't give that level of detail.
Okay. Those kinds of specifications generally lay out desired results and measurable outcomes rather than dictating the methods used to achieve them. So here, we probably left it up to Fluor as a contractor to how to supervise its employees.
Yep, and second, Boyle established a limited defense for contractors who comply with specifications. Here, the petitioner asserts that the Army itself found that Fluor violated the Army's instructions. So why would they get the benefit of the defense if they weren't even complying with the contract, so to speak?
Right. But remember, the Fourth Circuit didn't think that was enough. It suggested that the federal interest extended beyond protecting only those contractors that adhere to contract terms to a T. It treated wartime as different and used field preemption instead of conflict preemption.
Yeah, you're right, Ed. I tend to agree that when the court said that you don't generally want courts to regulate wartime activities during wartime, that's probably a true statement. Of course, there should be limits, right? Civil liability for stuff that happens during the fog of war seems like a very tough question, and that maybe Congress should step in to make a legislative determination instead of the courts trying to guess at what should be preempted or not.
So yeah, basically it's coming down to if we're telling the contractor to do something and they do it, we probably shouldn't hold them liable when it might go wrong. But at the same time, if we're telling them do something but we're not going to tell you how to do it and they do it in a really bad way, they should be held liable.
I think that's the question is, hey, there's this federal interest out there that we don't want state courts getting involved in. And the question really comes down to, one, does that matter that a contractor does exactly what we say? Or do we have to tell them exactly what to do? Or is it sort of this field instead of a direct conflict with what we say and what they do? Or is it this field in which, hey, they're a contractor, and so we don't want the eaches of their defense to be dependent on wartime or battle space decision making?
I also think it's interesting they're using Boyle, which is design specifications. Then this is a service that they're performing, which seem like two very different things.
Well, and I'm trying to wrap my head around the concept that we can take basically governmental immunity and give it to people that we contract for when we don't contract for inherently governmental functions.
Oh, that's a good point.
Yeah, that is a good point, Ed.
I see two flip sides on this argument. One is if contractors are now going to get sued for working with the government, A, they might not want to work with us, or B, the prices of what they're doing is going to skyrocket because they have to protect themselves from litigation, which I think is part of this argument. But at the other time, we need to make sure that they're still being held accountable. And if they're doing something wrong, that is the way that the American people can protect themselves.
Speaking of litigation costs, that's what our next case is all about, Ellie.
On that note, let's shift gears to the GO Group, Incorporated, a case focused entirely on the procedural question of appellate jurisdiction for contractors claiming immunity. What do you got, Ed?
So am I just getting called on for all the cases here today?
Yep.
But that's fine. I was well prepared. This one here is essentially a hypo from all of the Fed courts classes that we remember from law school, just getting throwback after throwback today.
Yeah, Ed, it does seem like the facts are not super convoluted, right? So it's whether or not the contractor is entitled to an immunity so that its case is immediately appealable when it's denied that at summary judgment, or whether or not it has to litigate the rest of the case and then take this issue on appeal after final judgment. So it's really an argument over whether the contractor can stop incurring litigation costs merely because it's a government contractor.
So in this case, the GO Group had a contract with Immigration and Customs Enforcement, ICE, and it argues that yearly immunity is a right not to stand trial at all, not just a defense against liability.
All right, I'm a nerd, but not a CivPro nerd, so you've lost me. What is the Yearsley immunity?
Well, Yearsley immunity, also known as derivative sovereign immunity, is a legal doctrine that shields government contractors from liability for injuries to third parties provided the contractor was acting under the valid authority and direction of the federal government, kind of like the earlier case. The immunity derives from the government's own sovereign immunity. Different from Boyle immunity, as that case is specific to design defect cases, but that's not really why I asked to talk about it today. This is the case where the FAR was brought up during oral argument.
Not like the distance, but FAR as in Federal Acquisition Regulation.
Dad joke.
Oh,
Dad
wow,
joke
Ellie.
time.
Oh, God. Yeah, that's right.
So the context was litigation costs then?
It was. GEO argues that litigation costs against contractors impairs the government's ability to discharge its current duties and recruit capable contractors in the future. If contractors are exposed to the full cost of discovery at trial, their ability to negotiate terms and price in litigation risk is negatively impacted by regulations like the FAR and the Anti-Deficiency Act. So making yearsly an immunity, as opposed to a defense, allows immediate appeal after a denial of immunity by the district court, and therefore can contain litigation costs incurred by the contractor.
Okay, so the question really then goes back to general cost principles in FAR Part 31.
Yeah, and this is where it came up at oral argument. There was a question about, I think it was Justice Kagan asked him directly, if litigation costs are your concern, can't you just seek recovery from the government either on the front end or the back end? And the attorney for the petitioner suggested that litigation costs were not permitted under the FAR.
Well, we know that's not always true.
Yeah, I agree. There's a ton of nuance, right? Aren't you a cost accounting person, like a cap?
I mean, it's not my specialty. I know the general principles. Do you want me to go into them?
Yeah, sure.
All right, let's see. So it has to be allowable. Cost must be reasonable, allocable, accounted for under the CAS or generally accepted accounting principles, permitted by the contract's terms, and not prohibited by FAR Part 31. Then there's a specific cost principle for legal costs.
And I pulled that one up over here. That's FAR Part 31.205-47. It outlines which legal costs are allowable. Costs associated with things like claims against the government, False Claims Act cases, whistleblower reprisal cases, or cases brought by federal, state, or local governments for violations of law. But it doesn't really talk about claims by private third parties. Any case law that I missed on that one?
So there is the TCOM case. The Court of Appeals for the Federal Circuit reversed a BCA when it decided that a contractor could not recover certain litigation costs. In the TCOM case, a private plaintiff alleged sexual harassment and retaliation by TCOM. After settlement, TCOM sought reimbursement, but the CAFC eventually held the costs unallowable because the contractor included the clause at FAR 52.222-26, which prohibited sex discrimination. So the rule was that if the contractor violated a term of the contract, then the costs would be deemed unallowable.
And that doctrine has been upheld a few other times since then, I think. That's where most of the litigation costs were deemed unallowable. And so while it seems weird that the FAR doesn't specifically call out any legal costs incurred while defending against a violation of law, I don't think it needs to in most cases. The way I think about it is using first principles that Ellie just mentioned, right? So is this cost reasonable, allocable, cap compliant, gap compliant? Is it permitted by the contract? Some violations of law may, in fact, not be reasonable. Surprise, surprise. While others won't be allocable to this particular contract, right? We're not going to say that fraud is allocable to this thing here. While finally, some other ones probably aren't compliant with general accounting practices like cooking the books or whatever.
Right. So when I listened to this oral argument, which I did so from the comfort of my desk in a chair,
Hater.
it sounded like there wasn't a ton of nuance given to this answer. But I do think the Practitioners' Council got it right. If the contractor will be found liable for violating law, those costs will likely be found unallowable. And if found not liable, then it should be recoverable, right?
Yeah, I think so, Ed. And I think that seems fair. What do you think, Ellie?
I guess the hard part is answering whether the contractor should have to incur the costs in the first place when it's a close question. That decision will factor into their decision to settle.
Yeah.
And like you alluded to earlier, bearing that cost at all will probably have an effect on pricing of contracts going forward.
Exactly.
Yeah, good points all around. I just to caveat, because we're talking to folks who may not be familiar with CAS coverage, not all contracts are CAS covered, right? Generally, only really high dollar non-commercial contracts are the kinds of things that we're talking about.
Yeah, there are quite a few exceptions to CAS coverage. For those contracts that aren't covered by CAS, the contractor can just bake in its litigation costs to its offer price.
Yeah.
Well, with both of these being argued this fall, hopefully we won't have to wait too long to get some decisions down from SCOTUS on these.
Yeah, I think it'll be fun to do a follow-up once the decisions come down. It's always good to talk about contracts and SCOTUS in the same breath.
I mean, maybe for you, Jason. I'll stick to my history. Con law was not my favorite class, right up there with Civ Pro. I was a property and contracts girl.
I am happy to continue talking about this as long as neither one of you make me run. That's the only thing I ask at the end of the day.
All right. Thanks, Jason, for coming down and talking SCOTUS with us.
Happy to be here.
Thank you for joining us today in this episode of Far and Beyond. Please make sure to follow us and subscribe on your favorite podcast platform.
We love to hear from our listeners, even those of you who do so while running. I am quietly judging you. Know that. Go faster. You're disappointing me. Please continue to reach out to us on Facebook and LinkedIn. The information can be found in the show notes from today's episode.
The views expressed today are those of the presenters, not that of the Judge Advocate General Corps, the Department of the Army, the Department of the Air Force, or the Department of War.